All right. Hi, everyone. You ready? Okay, let's start. All right. Welcome back, everyone. Hope you had a good week so far. I'm doing all right? Yeah? Very good. Any questions? Anything in your mind before we get started? Anything lingering? Anything bothering you? Anyone being denied judicial commissions? Anything? No? Okay. All right. Very good. So today we are going to be covering probably two of the most important Supreme Court cases of all time. And I don't say that lightly. This topic introduces you to the separation of powers. So in our last class, we discussed some in the abstract why the separation of powers is so important. We discussed Madison, that ambition must be made to check ambition or counteract ambition. We discussed what happens when you have members of the government who decide not to follow the law. When you have a governor who decides not to follow a desegregation order. We have a president who decides not to deliver commissions. And in both these cases, serious crises were averted by the grace of whatever. Who knows? These are cases where both the federal and state governments did something they were not supposed to do. They actually went ahead and did it. And it was only through a judicial declaration that they were pushed back in their place. Okay. The first case we'll cover today is a very, very famous case, which we'll revisit many times, called Youngstown Sheet and Tube Company versus Sawyer. This is a famous steel seizure case. All right. This case tests the issue of during a time of war, how much can a president do to ensure the war effort continues, even when Congress doesn't give him the power to do so. The second case we'll be doing goes all the way back to the Marshall Court, our favorite Chief Justice John Marshall. He wrote a lot of really important decisions. The first one you read was Marbury. The second one you'll read is McCulloch v. Maryland. You'll read a third called Gibbons v. Ogden in about a week or two. These are probably three of the most foundational cases we have. So what was McCulloch? The United States government decided to make a bank, not Bank of America, the Bank of the United States. Maryland wasn't too keen on having this federal bank, so it imposed a tax on this federal bank. Could a state tax a federal bank? But more importantly, could the federal government create the bank in the first place? You see, the issue of the taxation was almost secondary. And you may not have gotten it the first time you read the case. But the primary issue was whether the United States could even create the bank in the first place. For if the bank was not constitutional, there was nothing to tax. Both of these cases test separation of powers in very different ways. The first case is a separation of powers between the courts, the legislature, and the executive in time of war, where all three branches crashing into each other, trying to assert what their powers are. The second case, McCulloch, this is also a separation of powers decision, but not between Congress and the president. This was between the federal government and the states. And we see in these two cases two different conceptions of federalism and the separation of powers. Horizontal federalism, right, across between the courts, the Congress, and the executive. And what might be called vertical federalism between the federal government and the state governments. Although I'm not a fan of calling it vertical federalism because it makes it seem like the states are less important. They're not. They're not less important. But what we do know is what's supreme? Constitution. So above all else is a constitution and the laws made pursuant to it. So when Congress acts to pass laws, those laws are supreme over state laws. And that so much is clear from the Supremacy Clause. Okay? So these cases, which I grouped together, really test how we see the separation of powers between the branches of our government and the separation of powers between the states and the federal government. These themes will be tested over and over and over again in our country. They're being tested right now as we speak. These problems are nothing new. And I think you will continue to be amazed at how certain themes repeat over and over again in our system of government. So let's start with the foundation. Okay? All right, any questions before I get started? All right, very good. All right, and I'm going to pass around this roll. Just put your name on it. All right. So a little background first. Did anyone see the interview? Good. Okay, well, I actually liked it. I don't know why. Okay, so for background, those of you who didn't see it, this was a movie made about an assassination plot against Kim Jong-un, who's the dictator of North Korea. I promise I'm going somewhere with this, right? Why was this movie so controversial? Because North Korea is a brutal dictatorship of the worst sort on earth. It's a horrible place. Human rights abuses that you couldn't even fathom, okay? The fact that they even made a movie to suggest killing their dear leader, Kim Jong-un, was considered, an act of treason or whatever. So there's a lot of controversy of this movie, that there was a hack attack against Sony, which purportedly came from North Korea. Anyway, why is North Korea in such bad shape? Well, they've been in bad shape for a very long time. Shortly after World War II, Korea had a problem. There was a serious conflict. The northern part of Korea was basically being a proxy by the Chinese and the communists and the Soviets. The southern part of Korea became a proxy for America and other democratic nations. And the entire Korean War, Korean conflict was effectively a proxy of the Cold War. So you had the communists in the north, and the south you had the Western forces, and they were fighting something of a stalemate. Okay, this war never had a full resolution. In fact, Koreas are both declared at war with each other. They never actually resolved it. And there's what's called a DMZ, the demilitarized zone. There's a border between the two countries that's very, very hostile. Okay, but anyway, these countries are not doing very well with respect to each other. But during the Korean War, America had a very important role. So a few things to stress. First of all, this was about 7 or 8 years after World War II finished, right? There was no declaration of war. We discussed last week and the week before that one of the checks Congress has on the president is you can declare war or not. There was no declaration of war in this case. And in fact, if you read Justice Frankfurter's and Justice Jackson's opinion, they mentioned the only way to go to war is with a declaration. They were trying to gently nudge President Truman, saying, hey, this is not a legal war. Okay? But more importantly than that, for our purposes, this was a war that had a draft. Lots of American boys were drafted and sent to war. And part of this war effort was that the United States economy, once again, was turned into a war machine. Industry was effectively diverting resources to make cars and stuff so they can make tanks and airplanes and bombs and guns and bullets. One of the key ingredients in any war is steel. Okay? In order to make basically any piece of military equipment, you need to have steel. Just because the United States is at war doesn't mean everyone on the home front is united for that cause. People still have problems at home. One of the problems involved labor. There was a union called the United Steelworkers. And they were fighting for better wages, better working conditions, the usual litany of requests. The steel mills weren't willing to negotiate. This is actually the Youngstown Sheet and Tube Company in Youngstown, Ohio. Anyone from Ohio? Yeah. You know what Youngstown is? No? Okay. Okay. Yeah. It's in Central Ohio. I've been there. Here's actually a photograph of what the steel mill looks like today. It's humongous. Okay, but it's no longer active. All right. So you have this steel mill, right? And this is a fairly common occurrence. The workers want to go on strike. The employers say, go ahead, go on strike. Usually when this happens, there's a waiting game. How long can the workers hold out without getting paid? And how long can the managers hold out without producing any steel and making money? And in most labor cases, eventually someone caves. Either the union caves or the managers cave. Usually the union caves first because they need the money more. But these things can go on for a while. But there's a problem, right? The problem is when this steel mill shuts down, no more steel is being sent to the front. The war effort will be impeded. You probably read in the case that the Secretary of Defense submitted a declaration saying, listen, if you don't keep making this steel, people are going to die. American soldiers will not have the tanks they need. American soldiers will not have the guns they need. They will not have the planes they need. If you let this steel mill go on strike, boys will die. Okay? That's the background of this case. These are not light matters, right? This isn't something trivial as whether some random guy gets his Justice of the Peace Commission, right? These are serious, serious stakes during the times of war. All right, so as promised, Rob, let's start up there, okay? What did President Harry Truman do on the eve of this labor strike? Yes. Good. Exactly. On the eve of the labor strike, President Truman issued an order that said, I direct my Secretary of Commerce, Charles Sawyer. That's why it's Youngstown Sheet and 2 Company versus Sawyer, right? This is Charles Sawyer. I direct my Secretary of Commerce, Charles Sawyer, to seize and take over the steel mills. Okay. Austin, what does it mean for the government to take over a steel mill? Let's actually unpack that. What does that mean if the government takes over a mill?
They're taking over private property.
What happens to the workers if they go on strike? What do you think happens? One at a time. Austin, what do you think happens if the government takes over and seizes this mill? What do you think happens if someone wants to go on strike? Doesn't go to work. What do you think will happen to them?
They would get in big trouble.
Be precise. What's going to happen to them?
They'd be arrested.
They're arrested, right? Usually, when you have a company and you don't go to work, what happens? You get fired, right? Okay, well, they're going on strike anyway. That's what they're trying to accomplish. When the military, and make no mistake, this is a military takeover. When the military takes over a business and you decide to go on strike, you are arrested and held in a military prison. This is not a joke. So if you have a couple thousand union members, right, at this plant who decide to walk off the job, they'll be thrown in jail. No bail, unless you go back to work.
What if they don't quit? What's that? I mean, is it that serious?
Yes, they would all be locked up. Yes, if I had to guess, they would start putting them in a detention camp. This was a big deal. I mean, they don't discuss this much in the book, but they had military police roaming the mill, make sure people are doing their jobs. And not only doing their jobs, who's making the orders now, Hugh? Was it the manager of the steel mill deciding how much to produce and the quantity and stuff? Exactly. So not only was it takeover by the government, now the government deciding how much steel they make, where that steel's going, right? Who's going to make it, what the priorities are. If any of you have seen or read Atlas Shrugged, it's not too far from the truth, right? So we have this situation. We have this executive order, right? What's an executive order, Luke? Not they. It's the wrong pronoun. He. One. Yes. What's an executive order? What does that mean? He makes a decision on his own. Well, oh, that's true. An executive order is not Congress, but what's the force of an executive order? What's that even mean? Where's that? Like, what is that? Inherent executive powers. What's this? What's this word inherent? You use a good word. What does that mean? Inherent. Okay. Good. Right. You're on the right track. So we have this thing, and this is probably a little too small for you to read, but it's in your book also. Executive Order 10340, which directs the Secretary of Commerce to seize and take operation of steel mills. Now, we all know that this wasn't an act of Congress, right? We discussed last week for something to become law, it has to pass the House, has to pass the Senate, and then the President signs it, right? This is Schoolhouse Rocks. You learned this when you were in the 4th grade, I hope. Here, the President, on his own, at 5 in the morning, issues a piece of paper directing his Secretary of Commerce to take over the steel mill. So Shelby, what is this executive order? What exactly is the authority? Luke alluded to. What's the authority for this order?
Well, President also
Constitutional power. And actually, I'm glad you said that. Very often people say that the government has a right to do X. Tell them they're wrong. Governments have powers. People have rights. People have rights. Government have powers. Even the book makes a mistake all the time. Drives me nuts. Governments don't have any rights. That's not how it works. But yes. But thank you for saying that. Yes. So the government has a power, or the president has a power to do this. Okay? And that's basically what Truman said. He believed that any strike would impede the war effort. And that if they didn't take over the steel mill, troops would die. And that's a very stark image. Whenever you want to persuade a court, you say, Your Honor, if you rule against me, troops will die. That's a very powerful image. People will die. Okay? All right, so let's go through the timeline here, right? This order was announced only a few hours before the strike began. So, I mean, basically, he pushed it through to the last minute. Okay? He issued this executive order 10340. Let's see. Lauren, did Truman ask for Congress's permission before he did this?
He did. It wasn't 12.
Did he ask for permission?
No, he told him.
Okay.
Yes.
So
He let him know.
he let him know, yeah. FYI, right? So in Washington, there's a very a very common expression. It's better to ask for forgiveness than to ask for permission, which is all too often. So Truman did not ask for permission to take the mills. He sent them a letter saying, hey guys, guess what? I just seized this steel mill. You don't have to do anything. If you'd like to, you can do something, but don't feel obliged to help. Don't feel obliged to do anything. Right? Plowman, why do you think he gave him the option of acting? Why do you think he even said, yeah, if you guys want to do something, go ahead, but don't feel you have to? Why do you think he would do that?
Well, in the first place, the reason why he did this to begin with, I think, is because he felt it was a matter of national security, and it's the president to act
right
in such matters. And I guess he felt that if he were to give them the option, they would support him, because usually wartime presidents.
What would the significance be if Congress supports him after the fact? What would the significance of that be?
I'm not really sure.
What do you think? Is that Lauren?
Yes.
What would the significance be if Congress after the fact says, oh yeah, Mr. President, yeah, you can do that. We agree.
I think that it would show that what the president did in that form of an executive order, that they supported that.
Why? That's exactly right, but why? Why is it important for Congress after the fact to come in and say, yeah, go ahead, do that?
Why would it be good for Congress or for the
Congress, the country, the Constitution, all the above?
I think that it would show that the president was acting within his power. They would, if they supported
Yes.
him, it would.
Yes, you're exactly right. So it's often happened in American history that there was some emergency, right? The president acted alone. And that after the fact, Congress came in and said, we agree. They ratified it, if you will. If you ever hear the expression, like you ratify a constitution, Congress ratified the executive action. So one of the most famous examples is the Louisiana Purchase, right? You all know that President Jefferson decided to acquire what is present day much of Louisiana and the American Southeast, right? Does the president have the power to acquire land? No. That's for Congress to do so. And Jefferson basically acknowledged that he was acting unconstitutionally. But there was a deal that had to be done quickly. France was selling. He was like, all right, got to do it now. But after the fact, Congress came in and said, you know what, Mr. President, we agree. This was a good decision. So when Congress and the president agree, it shows that they're on the same page and that the Constitution is probably being complied with. Same for Lincoln, right? After the Emancipation Proclamation, we'll discuss this much later, which freed slaves in the rebel states, there was no legal authority behind it from Congress. President maybe could do it alone, maybe not. We'll discuss this later. But after that, Congress came in and ratified, said, you know what, Mr. President, we agree. You have the power to do this. So we're already sensing in American history where the president acts alone and the Congress gives your support maybe before or later. It's a safe bet the president's acting lawfully, right? So this is why Truman didn't ask for permission, right? He said, so if you guys want to back me up, go for it, right? Go for it. But don't feel obliged. To draw current events, not 4 months ago, the president of the United States announced that we would be attacking the Islamic State, or the Islamic State of Iraq and Syria, or the Islamic State of Iraq and Levant, ISIS, ISIL, whatever you want to call it. His announcement said, I have all the authority I need, but if you want to give me more, go for it. Okay, this still happens, right? The president's not asking for permission. He's asking for them to basically bless whatever he's done before. Thank you, sir. Okay. So he goes to Congress and says, hey, Congress, you know, I don't need your permission. I can do this by myself. I got this. But if you want to approve me, go for it. So is that Michael? Michael, did Congress give him permission? What did they do? Did they say anything? No, no. Did they say anything? Michael? Exactly. They were silent. Congress, after the steel seizure, was silent. They didn't say yes. They didn't say no. They were silent. Sarah? Sarah, what do we make of the fact that after the president took these steel mills and he asked Congress, like, listen, back me up here, boys, right? And they did nothing. What do we make of that silence?
That they weren't back on the top.
Were they? Can we say silence is consent? I mean, can we say that silence was sufficient to give power?
Yeah.
Think in terms of contract law, right? You also have contracts. If I say to someone, hey, would you like to make a contract? And you're silent.
I mean,
Can that bind you for assent?
No.
No. Usually, in some rare cases, silence can be a form of accept when behavior or conduct suggests otherwise, right? In contracts. But here, Congress is a silence like, dude, nothing.
But couldn't they have voted?
They could have voted, but did they vote?
No.
Why did they vote?
I mean, they were in a state of war. They didn't want to stop using.
So why didn't they vote yes? Why didn't they just vote yes, Mr. President, you can do this?
Congress ever vote on anything.
Good point. At this point, they did. Well said. Well said. At this point, they did, though. This was 60 years ago. What? Very good point. Demi, right? Demi, what do you make of the fact that Congress was silent? They didn't vote yes. They didn't vote no. What do we make of that?
My best guess is that they didn't know whether he had that power or not, but they kind of probably agreed with the thought of it, but didn't want to back it up because they didn't believe it was constitutional. They kind of agree with the idea, but not necessarily the process.
Interesting. Haley, what do you think?
I think that they didn't agree with it.
Ah.
They didn't think he had the power.
So why didn't they vote no?
I guess just maybe not to
So here's the conflict, right? So we have, three students, all very good answers. What do we make of silence? And you have three totally different answers. One says maybe they don't want to show division. Another says, oh, maybe they accepted, they don't want to say anything. Another said maybe they just want to take a vote at all, right? These are all plausible answers. But what does that tell us in terms of executive power? Did Congress bless this? Right? You're shaking your head no.
No,
Why not?
I think I agree with her. I think that they didn't agree with the president's action, but then again, they didn't want the country to think that they weren't supporting the boys by saying no. The president can't order them to make this deal.
All right. So we have the situation. So the president says, give me permission. Congress is silent. But, and here's the big but, while it's certainly true Congress didn't speak to this issue after the steel seizure, did they speak this issue before the steel seizure? Let's go in the back. Is that Ian? Did Congress ever speak to this issue before this crisis emerged? Okay. Good. What was this 1947 law? Good. Okay. So 1947, right? Not even 4 or 5 years before. Congress passes a law. It's this Taft-Hartley Labor Management Act. Don't worry too much about the provisions of this law. But for our purposes, what's important is that Congress considered what will happen in the face of a labor strike. And as a preface, 1947 was like a couple years after VE Day, right? The World War II had just ended, right? Congress was very familiar with wartime politics. I mean, the war had just finished a couple years earlier. And Congress considered whether the president should have the power to unilaterally seize steel mills. Connor, did Congress speak and give the president the power to unilaterally seize the steel mills?
I'm Jacob.
Oh, Jacob? Oh, just switch next time or change on my chart, either way. Yeah, that's fine. Jacob, did Congress speak to this issue? Did Congress decide to give the president the power, to seize steel mills by himself unilaterally? They didn't. What do they do? What do they do to this issue? Let's be very precise. Connor, you got it?
I mean, I think it basically deferred to Congress.
Yes. Yes. What Congress said was, if the president wants to seize this, the president goes to Congress for permission. Right? The law that Congress passed said, if the president wants to take over a steel mill, he needs to follow certain procedures that Congress set out. And this seems reasonable, right? Because after all, I don't think you've done this in property yet. You'll do it this semester. But the Fifth Amendment of the Constitution has something called the Takings Clause, right? You may have heard of a case called Kelo v. City of New London, where this woman's home was taken to develop and build some bigger and more beautiful things. The government has the power. I'm sorry, let me be precise. Congress has the power under the Fifth Amendment to take private property for public use with just compensation. So your property, your private property, can be used for public use as long as you're paid for it, right? Karishma, do you think if Congress wanted to, they could have passed a law taking over all the steel mills in the United States in face of war? Could Congress have done that? Oh, it's the exact opposite. If Congress passed a law, let me ask a question like this. Would Congress have the power to pass a law saying that all steel mills are now the property of the United States and the United States will compensate all the steel mill owners? Could Congress have passed that law? What power would have allowed them to pass that? I just said it. Yes, the takings clause, right? As communist as this may seem, right? If the United States government wanted to seize all the steel mills in the United States, and Congress passes this law and the president signs it, as long as there's just compensation and there's actual public use, I think Congress could pass that law. Now let's see the other way, Maurice. Does the president have the power under the Fifth Amendment to take property by himself? No. Which body of government has that power, Maurice? Exactly. Only Congress has the power to take private property. That's it. And you know what? Congress exercised that power. They said to the president, you know what? If you follow these procedures on this 1947 law, you can take the steel mills, but you have to do it our way. Not your way, our way. Okay? So we see that the power to take property is something that Congress has, not something the executive has. That brings us back to the case at hand. Congress in 1947 didn't give him the authority before. Congress in 1951 did not give him the authority afterwards. Okay? So let's think about this. Usually when the president acts, he acts based on several sources of authority. He acts based on the power given to him by Congress and his own powers. Brandon, in this case, did Congress give the president any power? No. So if Congress didn't give him any power, Brandon, what was the only source of power that the president could rely on? In which article? Or whose power, be more precise? His own power, right? Usually the president operates based on the powers given to him by Congress and the powers given to him by the Constitution. This is gone. There is no congressional power here. So all he has are his own executive powers, what I think Luke called inherent powers, right? All he has are his own inherent powers. This case, decided in less than a month, from start to finish, tests how big are these inherent powers? How far do these inherent powers reach? Can the president, relying only on his own powers, take over these steel mills? Right? This was a case of such gravity and importance I can't even begin to explain. Because this case, you had a sitting president who basically said, you know what, I'm going to do it anyway. Try and stop me. Go ahead, sue me, right? So the case is filed in the district court, in a federal district court. Actually, I read that they found the judge. Hold on. Where is it? They basically went to the judge's house in the middle of the night. They found a judge, the lawyers for the steel mill. They found a judge in the middle of the night, and they went to his house and were like, you need to stop this. The next morning, I think at 11:30 a.m., there was a hearing. And the government at this hearing said the president has inherent powers to do basically whatever he wants. They said there are no limits on the executive's power. 2 days later, only 2 days later, the trial judge, a district court judge, entered an injunction. He's restraining the Secretary of Commerce from taking over the mills. By the way, this was a Truman appointee. President Truman appointed this judge, and this judge stopped Truman. So this was a man of some fortitude to consider this. But think about this. In the middle of the war, people are shooting at each other. These people are about to walk off the job. And a judge says, no. Judge says, you can't do this. This was an act, I say fortitude, but I mean that. It would have been very easy for the judge to say, no, the president do what he wants. Time of war. This is not a matter for the courts to resolve. He didn't do that. The case was appealed to the Court of Appeals, and the Court of Appeals didn't even bother deciding. They said, I'll tell you what, we will put this order on hold if you go straight to the Supreme Court. So basically, This case began on, hold on, I will get the timeline. On April 9th, the executive order was issued, April 9th. Okay? By April 30th, the judge ruled on this. By May 2nd, the papers were filed with the United States Supreme Court. Arguments were set for May 12th. So 10 days after the briefs were filed, the case was argued to the Supreme Court. The case was decided on June 2nd. So basically, 20 days after the case was argued, the Supreme Court decided it. You think you have tight deadlines with legal writing? The entire thing from start to finish was about 30 or 40 days, which is blistering. And when you think of the importance of these constitutional issues, which were shot through so quickly, you have to recognize these people really were working steadfastly. So one of the reasons why the case was so divided was that they only had a month to write it. Usually the justices have time to, circulate their opinion, share it, provide edits, provide comments. There was no time for this. That's why virtually every justice wrote their own opinion. Much to your chagrin, perhaps. But the opinions are important because they illustrate very different visions of executive power. Very different visions of executive power. So I'll show you some faces because I like showing pictures. Oh, that's Sawyer. So the majority opinion was by Justice Hugo Black. He was a FDR appointee. Perhaps most famously, he was a former Klansman, which only came out after he went to the Supreme Court. Apparently, people in Alabama kept that under wraps for a bit. Justice Black wrote the majority opinion. Okay. Justice Felix Frankfurter wrote one of the other influential opinions. He was a famous professor at Harvard, brilliant professor, sort of a lackluster justice. Speaking of lackluster, we have Justice William O. Douglas, who also wrote one of the concurring opinions. He's very famous for being a philanderer. He had, I think, 4 or 5 wives, and he married several of his secretaries in sequence, not one after the other. He got divorced each time. He was actually a presidential candidate who couldn't run because he was a divorcee. This guy's the man. I don't say that life. So this is Justice Robert Jackson. So he was President Roosevelt's Solicitor General, Roosevelt's Attorney General, and he was a lead prosecutor against the Nazis at Nuremberg. This guy, he took a break from the U.S. Supreme Court to go to Nuremberg to prosecute Nazis. He's a remarkable jurist who is widely respected. But his opinion in Youngstown, although it was only concurring, is the definitive statement of executive power. So whenever anyone talks about Youngstown, you're talking about Jackson. In fact, in the last 4 Supreme Court confirmation hearings, I've checked this, every justice reaffirmed that Jackson is the right test. In fact, one other fun fact of history, who was clerking for Robert Jackson the year Youngstown was decided? William Rehnquist, the future Chief Justice of the United States. One better. There was a case in 1981 where the court reaffirmed Youngstown. Who wrote the opinion? William Rehnquist. Who is clerking for William Rehnquist? John G. Roberts, the current Chief Justice. So basically, you have an uninterrupted chain from Jackson to Rehnquist to Roberts of executive power. Just these kind of things, I don't get how they happen, but they happen. This is one of the only justices from Texas, Justice Tom Clark. If you ever go to the Supreme Court of Texas, you see his portrait very shining bright. And this was Chief Justice Vinson, who was the lead dissent. All right, so let's walk through each opinion one at a time. And we'll start with Black. Now, one thing you have to know about Justice Black is they like bright line rules. And everyone knows about bright line rules, right? It's either, imagine strict liability, right? There's no balancing, there's no negligence. It's either you're liable or you're not. There's no gray area. Justice Black was very much a fond of black or white issues. No pun intended, right? He saw things very directly. Okay, so Morgan, let's talk about Justice Black's opinion, right? What's Justice Black's general approach to this topic?
I think it gives some historical background with the Top Harley Act.
Okay.
Understanding why that Congress had already refused
Mhm.
this power in the past.
Mm-hmm.
And then goes through basically the arguments that the government brings up as POTUS's ability.
But POTUS is President of the United States. So SCOTUS is Supreme Court of the United States. POTUS is President of the United States. POTUS.
Great with my apps.
And also FLOTUS is First Lady of the United States. That's her Twitter handle. Okay, go on. I'm serious. It's FLOTUS. Good.
So the government's arguments that the President POTUS was acting under the Constitution in different facets, one being that he was the commander-in-chief, and one
Good.
as a lawmaker. So Justice Black refutes both of those.
Okay, good. So everyone, please take out your handy pocket constitutions for a minute. And if you turn to page okay, turn to page 27, okay? Okay. And it begins. We've read this clause many times. Article 2, Section 1. The executive power shall be vested in a president of the United States, right? Lauren, what is this executive power they speak of on page 27?
I think that it's basically power that, like you were saying earlier, that's not given from Congress, it's inherent power of the president.
Good. And unlike Congress, where it says all legislative powers herein granted, remember where they list and enumerate certain powers. We'll do that for the next case. It says the executive power, this huge body of power, is vested or given to the President of the United States. Now, Zachary, does the Constitution stop there? Does it only say the executive power shall be vested in the President, period, that's it? Does it go on to say other stuff? Good. So turn now, everyone, please, to page 30, right, in your Constitution. This is Article 2, Section 2. And it lists a couple of specific duties, right? The President shall be the Commander-in-Chief of the Army, right? What does this mean, Zachary, Commander-in-Chief of the Army and Navy? Good. But what triggers his war power decisions? A declaration of war. In other words, the President very well may be the Commander-in-Chief, but until Congress triggers it by declaring war, is he the Commander-in-Chief yet? Okay. So now here's the question which Jonathan won't want to answer. There was no declaration of war here. Congress never declared war against Korea. Why is he Commander-in-Chief? What do you mean he's not? What do you mean? Explain. Which way is it?
There's no war going on technically.
Is there no war? Oh, there are people dying and people shooting each other. It looks like a war to me.
The power of Congress was never requested, they never approved it.
And this has been the United States for the last 60 years or so. We have not had a declared war since Japan and Germany. We haven't. Okay? So if you notice the dissent by Chief Justice Vinson, the first paragraph talks about the United Nations, right? And it talks about this entire bit, how we joined the United Nations, and there was a resolution by the United Nations to bring all force to Korea. So basically what the dissent's arguing, and this argument is more credit than you may think, is that, well, we have international relations, and we have these treaties in the United Nations, and they want us to fight, so we should do it in accordance with the UN. And there's a school of thought that says the president's obligations under the treaty gives him the power, right? After all, Congress approved this treaty. The treaty says we have to do what the UN, we have to comply with the UN obligations. And the United Nations says we go to war, we go to war. I don't want to get into that issue now. We'll do that later, I promise. But for now, that was basically the basis of the president's war, that we had a UN resolution supporting it. What that does to the declare war clause, we will come back to that later, I promise. So now it says Commander-in-Chief. Another clause, which someone said, okay, the president shall take care that the laws be faithfully executed. Okay? right? The president shall take care that the laws be faithfully executed. What does this clause mean, Gabrielle?
That he has to follow the lawmaking that Congress has set forth.
Okay, this is it's on page 31. So basically, Article 1, Section 3. It says, he shall take care that the laws be faithfully executed. And you said, Gabrielle, say it again? What do you think that means?
I took it up that he has to faithfully abide by the law of Congress and court.
Be more precise. What does it mean to execute the laws?
He has to act on it.
Act on it. Good. What do you think, Emily? What does it mean to execute the laws? You always think of the executive branch, right? What does it mean to execute the laws? Not kill. Enforce. That's good. I like that. Enforce. So from the Constitution, we see the president has the power to enforce the laws. Emily, does he have the power to make laws? No. The president, no matter what he thinks, cannot make laws. So we go back to Executive Order 10340. That looks a lot like a statute, doesn't it? Right? Executive Order 10340 looks a lot like a statute. Had Congress passed that, is that George? George, had Congress passed that order saying, we declare the steel mills are going to be taken by the Secretary of Commerce, we give him these discretion, he does this, can arrest people, could Congress have passed that law? I'm sorry? Yeah, I think they probably could have, right? It's not entirely clear, but I think the answer is yes. So what Black is saying is that these executive orders seizing the steel mills were effectively laws. The president was engaged in lawmaking. Okay? The president cannot make laws. All he can do is execute them, and execute them faithfully. We'll come back to what that means in about 2 weeks. You'll enjoy that class. So Black is saying, listen, the president can only execute the laws, right? Is that James? James, sir, what about the fact the president's saying that, listen, I'm the commander-in-chief. Let's pretend the war was declared. Let's put that aside for a second, right? Let's say this was a declared war. Do the commander-in-chief powers stretch to the United States?
Black would say no.
Why would Black say no?
Because it's overstepping the powers that are delegated.
But aren't we in the midst of a war? And if we can't make this steel, that people are going to die in Korea?
Isn't the commander's power to direct armies
Direct armies where? In which location? Our shores? In the theater. So here's what Black says, right? And mind you, this was a couple years after World War II. We had just fought a bloody, brutal war. And what Black says is, listen, we understand there's a theater of war. And in the theater of war in Korea, the president can make these broad decisions. But at home, right? At home, James, who's responsible for making decisions at home? Congress. Congress makes these calls at home. Congress must do this, not the president. Black takes a very narrow vision of executive power. He's saying, listen, there's not even a close call here. This is not even close. Right? All right, everyone see that? Black is what we'll see over and over again. He's very much of a, he was like a proto-Scalia. He was a very strict guy. It's either right or wrong. There's no middle ground. When the First Amendment says Congress shall make no law abridging the freedom of speech, that means no law, none. He dissented in every single First Amendment case, saying that all these laws are unconstitutional. In fact, a true story, we'll get to this later, there were a lot of cases in the 60s involving obscenity, where they had movies like, porn basically, and the Supreme Court decided, is this obscene? And there was actually a movie theater in the Supreme Court where the justice would sit there and screen all these pornos. I'm serious. Justice Black would refuse to watch them because he's like, it's unconstitutional, it doesn't matter. He wouldn't even bother watching them. So this was a very, very interesting guy, Justice Black. We'll come back to Black a few times this year. Yeah, that's him. Very interesting guy. All right. Everyone go. Everyone can. Hugo Black. Any questions on Hugo? All right. Pedro, can you tell us, please, Justice Frankfurter? What was Justice Frankfurter's decision? How did he approach this issue?
Well, he mentioned other instances where the president kind of asked for this power,
Uh-huh.
like the Labor Management Act.
Good, right?
He mentioned that Congress has chosen not to do the seizure authority.
Good. Right. So Justice Frankfurter's answer is not quite like Black's, right? He's not saying that this is a strict yes or no answer. He says, listen, has Congress gone along with this, right? Has Congress given this power to the president? Because many times in the past, he mentions instances where the president's done stuff he probably wasn't supposed to, right? The president did something he wasn't supposed to, but Congress went along with it. And when Congress goes along with it, we have these two sources of power. You have the president's independent power, and you have the Congress's power, and they're acting together. And this is when you're at the strongest. What Frankfurter says is, listen, in this case, Congress already spoke to this issue. They don't need to say anything. In 1947, 4 years before, they said, the president will not have this power to take the steel mills. He doesn't have this power, right? He also makes some references to dictatorships and autocracies and arbitrary exercises of power. So Frankfurter recognizes very clearly the precedent that this can set. If Truman won this case, it basically gives a green light for the president to make laws during times of war. There's an expression which we'll study in a few weeks. We do the Korematsu case, the Japanese detention case. And it goes like this. During times of war, the laws fall silent. During times of war, the laws fall silent. And it's often the case that when people are dying, the law looks the other way. And we'll discuss this at great length. We discuss the detention cases the Japanese detention cases in Guantanamo also. But for now, Frankfurter says, listen, we're not going to take this lying down. Okay? All right, any questions on Frankfurter? We'll come back to Felix a bit. He was a catty guy. We next move on to Justice Douglas. Is that Gabriel?
Yeah.
Gabriel, what's Justice Douglas's position?
He said that when the U.S. pretty much takes over an industrial plant, the labor controversy is pretty much condemned property. He says that when the U.S. pretty much takes over an industrial plant, it's pretty much condemned property. He's concurring with saying that the president was overstepping his authority.
Yeah. So basically, if the government wants to take over the steel mill, they have to through Congress and have to pay compensation, right? But he makes another important point, right? Yasmin, what does he say about the fact there's an emergency? Does this emergency create a power in the president? Does the emergency vest the president with additional powers, Yasmin?
An emergency does have powers to do what's necessary.
Is that what Douglas says?
No.
What does Douglas say?
Douglas says that in this situation,
It doesn't. Why not?
because the power is with Congress, and he sort of talks about the checks and balances in a way, and he talks about how in order for him to do so, Congress would have to raise revenues, and that's the way they check the president.
Okay, good. So I'm going to get to you in a minute, Elliot, so your hand was up. But could the president even pay compensation if he wanted to? No. Usually when Congress takes property, they can pay compensation by withdrawing money from the Treasury. That's a power Congress has. The president couldn't. So not only can't the president take property, couldn't compensate them at all. So Elliot, let me ask you the question as well. Does the occasion of emergency create powers in the president?
I think Justice Douglas says that it doesn't create a power in the president, it just creates an occasion for which the power should be exercised.
But should be exercised or has been exercised? Should it be exercised, according to Justice Douglas?
I think it should be.
See, the way I read Douglas, and what I think Douglas is trying to say, is that just because you have an emergency, that doesn't give the president power. it gives them an opportunity to use that power. But whether or not that power is valid depends on what the Constitution gives them the power to do. In other words, it's often done during times of dictatorships. Hitler, Mussolini, whoever, they came to power during times of emergency. And they rose to power by saying, listen, things are really bad now. Give me this power temporarily, and I'll give it back. I'll relinquish it later. And the sad history of human civilization is that it never happens. That once power is amassed, it's seldom given back. Jason?
That's what I read in Douglas. I read that he was afraid of a Reichstag fire moment.
Yes. Explain what a Reichstag fire moment is. I hope
It's whenever Hitler seized total power from the German chancellor.
The Reichstag was the previous government in Germany before Hitler came to power. Yes, and again, this was decided, 5 or 6 years, not even after Pearl Harbor, right? I'm sorry, after the World War II ended. This was very recent. They were very familiar with dictatorships propping up and seizing temporary emergency martial law powers. I think Douglas is saying, listen, maybe today we have a kindly president, but tomorrow another president might use this power to do bad stuff. The checks and balances are costly, but you can't live without them. All right, so everyone see Jackson. I'm sorry, Justice Douglas. Any questions on Douglas? He was an interesting guy too. He and Black hated each other. They had these like 30-long-year feuds. And that brings us back to Justice Robert H. Jackson, who himself, as I mentioned, was a prosecutor at Nuremberg. He prosecuted the Nazis. He was very familiar with how the Nazis came to power and what happens when you relinquish your rights. He knew firsthand how quickly a Western democracy like Germany could descend into total dictatorship in a matter of years. He got that. Okay. Is that out? No. No. Oh, sorry, right there. Amanda, what did Jackson say? What was Jackson's, not details, what was his general thrust of how you interpret the Constitution, how you resolve these issues?
Well, he talked about how you don't rely necessarily, or you don't express the text of the Constitution itself.
Good.
That you, I guess, sort of look to the way that the three branches interact. And
Very good.
they fluctuate.
Very fluctuate. I love that word. Good. So Jackson is not like Black. Black said, listen, you have the text of the Constitution, strict liability, no go. Right? Jackson says, listen, we can't resolve such an issue of importance by a literal reading of the text. By the way, Jackson was one of the greatest writers of the Supreme Court. This opinion was beautiful. I mean, it was written in about 2 weeks. But his prose is so good. It's a treat to read. He begins by saying that, listen, I served in the Roosevelt administration, and those experiences influenced my views. He says that there's a poverty of useful authority to resolve these problems. We don't have any cases in the books to resolve this. This was, in a word, unprecedented. It had never been done before. He says the art of governing can't conform to isolated clauses of the Constitution. And he says that presidential powers are not fixed. They fluctuate. How do they fluctuate? Depending on the conjunction or disjunction with Congress. What is, I think you're in the wrong seat. What's your name?
Joe.
Joe, you're in the wrong seat. Just fix it later. Joe, what does this mean, this conjunction and disjunction with Congress? What does that mean?
Well, if Congress either gives the president authority or passes a law that says, hey, you are allowed to do this, then that's when the president is acting with the most authority.
Mm-hmm.
And if Congress is mute on this or doesn't say anything, then he's kind of in a middle level.
Okay, we'll get there. We'll get there in a minute. What do these words conjunction and disjunction mean? You already answered it, but just the words conjunction and disjunction.
Conjunction would be when they come together, and disjunction would be when they go in separate ways.
Yes. By the way, yes. So thank you for whoever shouted that. Read Justice Jackson's or listen to his opening statements at Nuremberg. He was a remarkable lawyer. There are very few lawyers that everyone loves, and he's one of them. It's very famous that he was a Solicitor General of the United States, and then he got appointed to the Supreme Court. And the justice was like, no, we don't want him in the court. We want him to argue cases because he's so good. He's a remarkable guy. But we have these phrases, right? Conjunction and disjunction. I think John? Yeah. Joe. I think Joe's definitions were pretty good, right? Conjunction and disjunction means, is Congress overlapping, right? Is Congress agreeing with the president? Disjunction means, is Congress pushing away or going in the other direction? Why is it so important to check whether Congress is conjoining or disjoining? Is that Alana?
Yes.
Alana, why is it so important to determine whether Congress is with or against the president? Why is it so critical?
To determine if the Congress is with or against him.
Why is that so important?
Well, the Congress has to agree with them.
Do they have to agree?
Yeah.
Well,
Well, the president can't do anything unless the Congress backs him.
well, okay, so backs him doesn't necessarily mean agree. So I want you to take away from Jackson's opinion is this isn't a simple case whether Congress passes a law saying, yes, you can do this, and the president does it. There's some wiggle room, right? There's some gray in the middle. There's this area of twilight, this twilight zone, where it's not quite night, it's not quite day, this hazy middle ground. And that's the insight that Jackson brings to our constitutional law, which is why he's so revered. Right? You can't resolve these cases based on a strict formula. There's not like the 4 elements of negligence or whatever, right? There's not like how to form a contract. There's not the statute of frauds, right? This is why constitutional law drives law students nuts, because there are no bright line rules. And Jackson makes that point so explicitly. This isn't about bright line rules. This is about seeing, are they in the same ballpark, right? Is Congress in agreement with the president? Maybe not agreement with the president, somewhere in the middle. Okay, anyone questions so far? So Jackson puts together what he called these 3 tiers. And a lot of students think these are bright lines, like, oh, are you in tier 1 or tier 2 today, right? Now, these are ways of thinking about our constitutional governance. And we will come back to this over and over and over again. So I want you to understand not just what the 3 tiers are, because your Hornbook can list you for that. I want you to understand why these 3 tiers exist the way they do. Okay? So let's start. Is that Renee? Renee, okay. Let's start. So Jackson discusses this first tier, right? Where the authority is at its maximum. Renee, what are the reasons why the president is acting with maximum authority? What gives the president such heightened authority?
He's acting with his own right plus the all the authority that Congress.
Exactly. There's maximum authority when you have the Congress's powers plus the president's powers. You have both. You have Congress plus the president. Or put this in terms of the Constitution. You have Article 1 plus Article 2. You'll need to remember these, but not too long. Article 1 is Congress. Article 2 is the president. Don't forget the example, the open book, you can always check. But you have to know, there's maximum authority here. Not because of any clause in the Constitution, but the entirety of the elected branches of government agree that this action is lawful. And for Jackson, that's good enough. It gets, quote, the strongest presumption of constitutionality? Is that Jennifer?
Yes, sir.
Jennifer, what does this mean, the strongest presumption of constitutionality?
Because both the president and Congress are agreeing to the powers of Congress.
Correct. What does this phrase mean, the strongest presumption of constitutionality? What does that mean? What's a presumption?
Like assuming.
Yeah, it's an assumption. But why? What does it mean to have a presumption of constitutionality?
I guess meaning that the president and Congress are both have the same idea of what should be going on, and they're agreeing with each other.
Good. Is that Megan? Megan, if there's a strong presumption of constitutionality, and you're the steel mill trying to challenge it, what kind of burden do you have? Is that a high burden or a low burden? Really high burden. I would almost say an insurmountable burden. So what you'll find about constitutional law is that there are lots of tests, right? And we'll go through more tests than you'll care about. But at heart, the question is there some sort of presumption of constitutionality? Is the judge putting his thumb down on the scale of the government, right? At that point, the individual, the steel mill owner, has such a high burden that he's not going to win. That once you have attaching this presumption of constitutionality, the government wins. The government has no burden at that point. The whole burden of proof is placed on the individual. Okay. One last point, Mary, on the Zone 1. Does Congress have to expressly pass a statute giving the president this authority? Does that have to be very expressed? Under Jackson's first tier. Explain more. Does Congress have to pass a statute saying, we give the president the right to seize steel mills, period? Do you have to have a very express statute on point?
Well, we're going to encourage that, yes, since they had already passed acts saying that.
No, not this case, in general, right? Under Jackson's first thing, do you have to have an express statute on point making that authority given? Well, let me ask you this question. Do you know the difference between expressed and implied?
Well, expressly, they would say flat out,
What does implied mean?
implied, it would allude to them having the power, but
Good.
not be.
Right. So basically what Jackson says, I'll explain this more, is the authority can be both express or implied. Express means Congress says, we are giving you, the president, the authority to do this. No questions. But Jackson isn't so strict. He says also it can be implied authority. Is that Crystal? Crystal, what does this mean, implied authority? What does this look like? So what would an implied authority look like? Try to imagine. How could Congress give the president the authority to seize steel mills by implication? What would this look like?
President shall act according to what he thinks is reasonable for times of war.
That's very good. Better than what I was thinking of, right? What if the statute said like this, right? During the times of war, the president shall take whatever actions necessary to manage labor relations crisis. Would that work? I think that'd work. Right. So the statute doesn't specifically give the president the power to take the steel mills, but it's like whatever is reasonably necessary during times of war. If there's a labor crisis at steel mills, I mean, there might be some other problems with that, but that seems to be a pretty good indication that Congress saying, listen, we don't know all the crises that may emerge. Lots of things can happen. We don't know. We trust the president to manage this.
Could it be implied that they gave him permission by not voting on it, by not doing anything?
Oh, now we get to zone 2, so we'll get there in a minute. But I think Crystal is correct that, you know, some sort of implied power, right? It's not direct, but it's like, listen, you can do what you need to do. Do what you got to do. So here, the president has maximum authority, right? And basically no court will take any steps to invalidate this. Okay, Hector, let's go on to zone 2, what Justice Jackson famously calls the zone of twilight. And if you've ever seen the show, The Twilight Zone, I'm positive they ripped it off from it. I can't prove it. But the word twilight, for those who don't know, it's this time between, day and night, where the sun is setting. And it's kind of light, it's kind of dark, you're not quite sure what time of day it is. You're in this state of twilight. So Hector, what is this twilight zone that Justice Jackson speaks of?
It's power that he uses concurrent with that of Congress that Congress fails to check.
Say that again in your own words.
He might do something and Congress fails to either ratify it or disclaim it.
Okay. This is the area where we don't know what Congress thinks. Right? Congress either didn't give authority, express or implied, no express or implied authority, or silence. We don't know what Congress thinks. They haven't given authority directly, or maybe they were altogether silent. Is that Connie? Connie, what do we do in such a case, according to Jackson, where Congress is silent? We don't know what Congress thinks. How do we handle this?
I think he's trying to describe the beauty of the way the Constitution works together, and you're going to let the events
Yes.
take place. And you're going, it's just not like this strict parent, like you're looking at as a family, they're going to work together, like interdependent, based on what's going on.
Okay, that's a perfect answer. Okay, ready? You have to look to the imperative of the events. Okay, what do we mean the imperative event? Basically, a case-by-case analysis. When you're in zone 2, there's no bright line rule. Right? You have to do the best you can to try to figure out, go back to our words before, the conjunction and disjunction with Congress. You have to figure out how close is the president to Congress? Are they in the same ballpark? And he lists a few different things. I want to focus on one word, which is a word which you may have seen before, but not. Acquiescence. He wrote quiescence, but it's basically the same as acquiescence. Do you know what acquiescence is? Vicky, tell me, what's acquiescence? What does that mean? Okay. Alita? I'm sorry, Alita. What does acquiescence mean?
I guess giving your assent or your.
What kind of assent? To be very precise. Give me. Maybe use it as an example. That might help. Give me an example of acquiescence.
Basically, if I don't know, if Michelle asked me to go to lunch, and instead of saying expressly yes or no, I just walk with her.
Okay. So I'll give you an example of acquiescence, right? And someone just did it, right? Someone gets up and goes to the bathroom, right? I don't say anything. Actually, I don't care, right? Some professors care, some professors don't. But every time someone gets up and goes to the bathroom, I don't say anything. You all pay attention, right? I'm sure you do. And you see, I don't yell at people for getting up and going to the bathroom. Some professors do that. And what do you learn? What lesson do you take from this, Leila? What do I care about going to the bathroom? No. That's what acquiescence means. Basically, right, I'm the executive, or sorry, I'm Congress, I'm the lawmaker in this class. I lay down the law. And if I don't really make a fuss about you going to the bathroom, I'm probably okay with it. Do I ever say, you can go to the bathroom and you don't need to ask me? Have I ever said that? No, I don't need to. But my behavior as a lawmaker in this class is, yeah, go up and go pee. I don't care. Just be back quietly, right? Same exact dynamic applies with Congress. If the president keeps doing something and Congress doesn't really say anything about it, they're silent, that's a pretty good indication that Congress is okay with it, that Congress supports it, right? That's acquiescence. Congress supports it. Yes, ma'am.
Wouldn't that kind of depend on the relationship between the president and Congress? Sometimes Congress silence is to intentionally make the president look bad.
What could you possibly be talking about? Well, we will do that. I'm so glad you said that. We will discuss this at great length. So yes, sometimes Congress is silent because maybe they acquiesce. And perhaps sometimes Congress is silent because they don't agree with the president politically. And they don't want to give him the authority. Not to put a too fine a point on this, but the case of Texas v. United States, which I filed a brief in for full disclosure, involves the constitutionality of the president's executive action immigration. Congress is threatening and voting to defund this action, and President Obama is looking to veto that defunding bill. There's a court right now with arguments already submitted deciding whether Youngstown's been violated. I'll discuss this in about 2 weeks, but this is a very live issue, a very live issue.
I was gonna say, like, this morning I saw on the news that even though, you know, like, for example, doesn't the Speaker of the House have to invite the President for the State of the Union, technically?
So what's interesting is that, and we'll discuss this later, but Congress has no duty to do much. They have no obligation to pass any laws, and no obligation to vote on anything. One of the few things Congress must do is receive the State of the Union. Why? The Constitution says the President shall deliver a State of the Union. In order for the President to do that, Congress has to receive it. In other words, if Congress doesn't receive the State of the Union, the President can't give it. But there's no obligation for the President to give it in Congress. In fact, President Jefferson gave a written statement. So short answer is he doesn't have to, but it'll be really stupid not to.
Well, what I was getting at is I saw this morning that the Obama administration was pretty ticked off that Congress invited Netanyahu without even consulting him to come speak to Congress.
Well, I won't get too far into this, but foreign affairs are a very tricky issue because usually the president is called the sole organ of foreign affairs. But a number of foreign dignitaries have spoken to the United States Congress before, but we'll go too far into that. So we look into this conjunction or disjunction, right? In this zone of twilight, it's a case-by-case situation. This is not a case where we have a bright line rule. We look to acquiescence. Has Congress not objected when someone goes up and goes to pee, right? Is this a form of acquiescence? Okay, everyone with me so far? Okay, and Michelle, let's finish it up. What's this third tier that Justice Jackson describes?
This is basically where the president is like working on himself.
Yeah, exactly. 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 This is what's often called the lowest ebb. And if you've ever gone boating, you know there's high tide and low tide. And if the tide gets too low, your boat gets stuck. I'm sure you've seen pictures of this, right? Your boat basically bloop, tips over. The president acts as lowest ebb when it's incompatible with the express or the implied will of Congress. Okay? Here, the president has no Congress, so there's no Article 1, only Article 2. What does this mean? The president cannot rely on any executive powers. All he can rely on are his own inherent powers. There's nothing from Congress. So while in Zone 1, he's relying on the sum of both, right? He's relying on all the powers of Congress and all the powers of the president. Puts him at the max. Here, he only has his own powers. Okay. So what happens then? Is that Maria? What happens then when the president's acting only in his own powers? How should courts react to that?
Well, they're the ones who need to make sure that they're balancing making sure the balance of all the powers is in order. So the courts can pretty much agree with the president by, I guess, kind of saying that Congress is wrong if they pass something.
Let me ask you like this. So we said in the first zone that Congress has something of a presumption of constitutionality, like we presume it's constitutional. What's the presumption here in the third tier? Is it a presumption of constitutionality?
No.
What is it then? How would you describe it? If it's not a presumption of constitutionality, what is it? Not of his powers. What do you think, Adela?
Presumption of
Yes, yes. It's effectively the opposite, right? It's a presumption of unconstitutionality. In other words, the court starts off with the presumption that, wait a minute, Congress said no to this. The president's doing it anyway. There's a pretty good shot he's going to lose this one, right? So your starting frame. So who here then, Della, bears the burden? Does the government bear the burden, or does the steel mill owners bear the burden under this last tier?
I guess the.
Exactly. The government has the burden to prove it's constitutional. The government has the burden of proving why this is constitutionality. In the first tier, the burden's on the individual to prove that this action is unlawful. But here, because you have this presumption of unconstitutionality, the burden is placed on the government. And like I said, when you have the burden of proof in constitutional law, you're going to lose. In almost every single case, and there's a few exceptions, in almost every single case, when you have to justify your actions, you're going to lose. And we'll discuss this later, but this presumption of unconstitutionality is sometimes called a presumption of liberty, right? It's a presumption that the individual wins. It's not that the government wins, presuming is the individual wins, that the government's acting unlawfully. And I want to focus on one phrase that we'll come back to. Jackson says you must scrutinize with caution. What does this mean? Is that Whitney?
Yes.
What does it mean to scrutinize something with caution as a judge? What does it mean to scrutinize it?
Analyze it.
Analyze it how?
They need to analyze whether the power that he's using is within his constitution.
Is this a rigorous examination, or you kind of just glance at it? What does it mean to scrutiny? Right? Write this word down in your notes. Come back to this over and over again. Think the scrutiny or scrutinize something, right? It's how closely you look at it. Like, if I want to scrutinize this, I'll bring it right up to my eye and stare at it. In constitutional law, scrutiny refers to how closely you look at something. The closer you look at it, the more errors you find. It's true for anything. If you look at any problem, you start looking at it real close, you find all these problems with it. And these are problems of unconstitutionality. So what Jackson says is when you're in this third tier, you got to scrutinize it real close. You don't give the government the benefit of the doubt. You apply a presumption of liberty, right? This framework has basically been the canonical, by canonical I mean the official framework of constitutional power for almost 60 years. Okay? So let's actually apply it. Tiffany, let's walk through this, right? According to Jackson, are we in zone 1? Has Congress given express or implied power to the president to take the steel mills?
No, they didn't.
Clearly didn't, right? They did not do it. They did the opposite. They said you don't have this power. Whitney, Tiffany, are we in zone 2? Is there some sort of ambiguity or unclear whether Congress supports this action?
No, because he wrote that prior to this, Congress has 3 statutory policies inconsistent with seizure.
Exactly. Congress spoke to this exact issue and did not give the president this power. So bring it home. Where are we? Where do we find our home?
In the 3rd tier.
In the 3rd tier. And this is the most severe of the tiers, where the president's acting only on his executive power. Okay, very good. And Cindy, does the president have this power? That's my question. You're right. In this 3rd tier, does the president have sufficient power to do this? No, why not? Why does Jackson say in this 3rd tier the president cannot seize the mills? So you jumped the question.
Because the Constitution doesn't give.
I'm sorry?
Because the Constitution doesn't give permission to do so.
Be more precise.
None of the powers given to the president implies or expressly says that he has the power to seize without the authority of Congress.
Close. Alejandro, why does Jackson say that the president lacks the power in the 3rd tier?
The Constitution lists certain powers that
Good.
are given to the executive branch, and this is not one of them.
This is not one of them, right? So it's not acting as commander-in-chief because he's doing it domestically, right? This is not about vesting executive power because it's a lawmaking power. He also says this is not taking care of the laws that faithfully executed because he's not executing the laws. That's the point. He's making up his own laws as he goes along. But what about, Alejandro, let me ask you a follow-up, please. It was mentioned before, these inherent powers. What is this one of the executive's inherent powers?
Well, no, Jackson talks about war powers, how the defense brought that up, but Congress has the power to declare war, so it's not the president's duty to.
Good. So what's interesting here is that the scope of the president's executive powers depend on what Congress has done. And this is why Jackson's so important. If you're still in zone 2 and the president's acting on inherent powers, there's a pretty good shot he'll win because it's unclear what Congress thinks. Or Congress says, no, the president cannot do this. Relying on inherent powers is not going to get you very far. He says this is an authority of power without war. And the closing of Jackson's concurring opinion is beautiful prose. And he speaks about Nazi Germany directly. He speaks about the Reichstag in Weimar, Germany. And saying, listen, there's lots of countries where there's emergencies. And when emergencies happen, the executive claims authority. This is an exercise of authority without law. And he admits that, you know what, our system has defects and delays and inconveniences. But there's no other method for preserving free government other than congressional deliberations. The only way man has discovered to preserve free government is to have congressional deliberations. And this last sentence I'll read to its entirety. Such institutions may be destined to pass away. Maybe free government will go, who knows? But it is the duty of the court to be last, not first to give them up. This is John Marshall speaking. The courts will be the last ones, not the first ones to give it away. In other words, for my cold, dead hands, if you will. Jackson will not give this up. Read it again when you have a chance. It's beautiful. Okay? All right, let's skip Justice Burton with no disrespect to Justice Burton, but after Jackson, no one really cares. Let's. He was not a very consequential justice, so it's whatever. Okay, let's go to the dissent, though. Is this Sean? Sean, what does Justice Vinson argue in dissent? Why does he think Truman wins here?
Well, he's wanting to look at the context. And he's basically saying because we're in a time of war, the preservation of the Union must come first.
Yes, sir. That's exactly right. The dissent is, listen, we're just judges here, right? We're not on the front lines. We're not in the battlefield. When we write our decisions, we're going to go home at night and sleep in our beds and be warm. No one's going to be shooting at us. We have security guards. But if we rule against the government here, our boys overseas will get shot at, and they might not have bullets to fire back. He says this is not even a close call. And the case was 6-3. It wasn't 5-4. It was 6-3. That the president can do this lawfully. The entire dissent is not so much grounded in the text of the Constitution. It's, in other words, like Sean said, look at the context here. Let's not be stupid, right? This is this is in the ballpark of what presidents can do. It'll be temporary. Once the steel labor crisis is over, they'll go back to normal. But this was the dissent. This case lost for the government. So the aftermath of the case, I think, proves Jackson right and the dissent wrong. So within minutes of the Supreme Court's ruling, Truman ordered that the Secretary of Commerce release the steel mills. Again, we had the potential for a crisis. What if Truman said, no? What if Truman said, sorry, I'm going to hold on to these steel mills. We need this steel. Thankfully, he didn't say that. He said, you know what? Go back. Think of Jefferson ignoring the commissions or the governor of Arkansas standing in the schoolhouse doors, right? Again, an executive did the right thing. The strike lasted 50 days. Apparently, our war effort wasn't that much impeded. So I want you to take from this a lesson that during times of war, the government lies. And I don't say this lightly. They've admitted to it. They've admitted to it. So during the Korematsu case, which we'll study in a couple weeks, the government submitted these affidavits to the Supreme Court saying that we have intelligence that Japanese Americans are serving as spies for the Japanese and that we need to round these people up, put them in camps. People in the Solicitor General's office, the top lawyer of the government, they knew this wasn't true, but they submitted anyway. About 3 or 4 years ago, the Solicitor General, Neil Katyal, submitted a letter to the Supreme Court saying, we apologize for this. We submitted documents to the court that were false and we knew it. And we're sorry for this. They admitted they lied. And it was on the basis of these false representations about the danger of Japanese Americans that they locked them up in the internment camps. And the court upheld that program. We'll discuss the details later. So be very, very careful during times of war with government representations. And I think Jackson was almost calling their bluff, saying, listen, this is not that big of a deal, you guys. This is not that big of a deal. A funny story, I read this, it might be fake, but apparently Justice Black with majority invited Truman over. And Truman said, Hugo, I don't much care for your law, but by golly, this bourbon is good. So even afterwards, the government's lubricated by some good bourbon. We're able to get along. This case is really important. Hope you all get the severity of it. Is there any case in this before we move on to McCulloch? Anything? Yes, sir.
I guess the Fifth Amendment doesn't necessarily state conclusively that the taking clause is a function of Congress.
Ooh, good question. It doesn't.
But it's construed because
yes. In fact, if you come talk to me after class, it's unclear exactly if the Congress even exercises a federal eminent domain power. It's a really complicated question, but the Fifth Amendment does not say anywhere that Congress can exercise it. Ask me later, but it's actually a really difficult question that's not been given enough attention. Thank you. All right, any other questions? All right, so let's move on to McCulloch in our remaining time for today. So over the next, if you turn to page 23, please, in your little pocket constitutions. Okay, if you turn to page 23, we have Article 1, Section 8. And Article 1, Section 8 lists a number of powers of Congress. There's about, how many are there? Like 20 or so. I always forget the exact number. These are what are called enumerated powers. Neffy? Sir, what does it mean to have enumerated powers?
It's basically, it's literally written out power.
What does enumerate mean? What's that word mean?
Number?
Yeah, to count, right? To enumerate, to list out by number. The Constitution lists specific powers that Congress has. The power to lay and collect taxes, the power to borrow money, to regulate commerce, establish rules, coin money, establish post office. You could read them. We start off, now I've turned back a few pages, if you will, to page 17. The very first words of Article 1, Section 1. Article 1, Section 1, on page 17. All legislative powers herein granted. Herein granted. What does that mean? Is it Andrew? Andrew, what does it mean herein granted?
Powers are listed or granted
Listed where?
in the article.
Article 1, Section
3.
Well, the one I just read.
Section 8.
8, exactly. So Article 1 says, Congress has all the powers herein granted. All the powers granted are in Section 8. So you want to make a little note in your Constitution. Herein granted refers to Section 8, or page 23, if you will. All the powers Congress has are granted in Article 1, Section 8. Right there, first words of the Constitution. Okay? Is that Caleb?
Yes, sir.
Caleb, does Congress have any powers beyond those listed in Article 1, Section 8?
Yes.
No, actually.
Oh,
Because where is the necessary and proper clause?
and
Section 8. So let me ask you the question again. Does Congress have any powers beyond those listed in Article 1, Section 8?
No.
I did not acquiesce to that. Right. That's right, no. Congress has no powers beyond those listed in Article 1, Section 8. Everyone get that? Now, they have a lot of stuff in Section 8. It's a long document. So we say often that the president has inherent executive powers. Brandon, does the Congress have any inherent congressional powers? Do they have any inherent unenumerated powers in the ether?
Yes, no.
No. It says it right there. In the first sentence, all legislative powers herein granted. So there are no congressional powers beyond those given by the Constitution. Everyone with me so far? But, and Caleb wisely alluded to it, there's one provision in Article 1, Section 8 that's very, very, very broad. So if you turn to page 25. You ever see these videos on YouTube of babies with magazines and they're swiping because they have no idea what to do? They don't know how to turn a page. There are pictures. You give a baby a magazine and they start swiping. They don't know how to turn a page. Wait. These were my students in like 2 decades. I mean, I'm getting ready for it. Anyway. So on the very last line of Article 1, Section 8, it's on page 25 of your little books. We have what's called the necessary and proper laws. This is Clause 18. Okay? Right there. Read it first, please, Jocelyn.
To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States and in any department or office.
Very good. Okay. This was probably the most controversial and probably important provision of the Constitution in the 19th century. And the reason why it's so important is because it addresses a problem of the Articles of Confederation. We discussed this on the first day. Recall the Articles of Confederation give Congress very narrow powers. Unless a power was expressly delegated, that was the language used, unless a power was expressly delegated to Congress, they couldn't do anything. This gives them very narrow power. So, Stephanie, let me give you an example. So, right, so the Congress has the power to make post roads, right? That's listed right there. That's an easy one. Do they have the power to buy horses to go along these post roads?
Yeah.
Do they have the power to hire postal employees to carry the mail? So the power to, rent property along the road to build post offices. Okay. Are any of those things, buying horses, employing, postmen, renting property, are any of those things listed?
No.
What's that word implied? What does this mean implied?
Kind of like we were talking about earlier, you have to make something happen, to execute the power, basically.
Very good. So the framers of the Constitution recognized that you can't possibly list every single thing a government has to do. So you start with the simplest one. I always use postal roads because it's easy, right? Constitution says you make post roads. Well, look, you need to buy horses, you need to hire mailmen, you need to rent property to build a post office, you need to print stamps, you need to buy paper, right? There's all these different things that have to happen to run a postal service. So the Constitution says they can make all laws which are both necessary and proper to carry into execution these powers. Now, the Constitution does not say they can make any law to carry into execution the powers. They didn't say Congress can do whatever they need to get the job done. I think that's the language you use, right? They didn't say Congress can do anything they need. They said only those powers that are necessary and proper. Step one? Yes. What does these three words mean? In your language, don't worry about John Marshall. In your language, what does this mean, necessary and proper? How do you understand this?
They can do whatever they need to do.
Anything. What does necessary mean?
Well, anything that is needed to.
Needed. Well, is that anything? Okay. Patrick, is that Patrick?
Yes, sir.
In your mind, how would you understand necessary and proper?
I guess acts that are not specifically mentioned under Congress's power that are required in furtherance of things that were enumerated.
Now, Juan said anything goes, right? Would you understand it the same way?
Yes, as long as it's not conflicting with other checks imposed on Congress.
Okay, good. Mitchell, your turn. How would you read these three words, necessary and proper?
A little bit of what both of them said is just things that are required.
Required. Okay, good. All right. So here we have again three students, all give good answers, understanding three words in the Constitution that have torn this nation. So there are two main ways of understanding necessary and proper. Okay, there are two main ways. One is necessary. This was a view advanced by James Madison and Thomas Jefferson, among others. They said, look, it's only that which is required, to use, I think, Patrick or Mitchell's word, that which is required. So look, if you want to run a postal service, you need horses. There's no way to have a postal service without horses. You need people to carry the mail, right? You need people to print the stamps. You need people to, rent land for post offices. You cannot have a postal service without horses, right? Let's give an example. What about sponsoring Lance Armstrong's racing team, right? Mitchell, is that necessary to have a post office to sponsor Lance Armstrong's steroid-fueled racing team? No. But is it perhaps helpful to sponsoring, to running a post office to have this racing team?
Allegations aside.
Yeah, right? At times. Right. The second view, advanced forcefully by Alexander Hamilton, was that necessary meant convenient. Alexander Hamilton forcefully argued that necessary means convenient. He said, listen, it doesn't have to be absolutely strictly necessary as long as it's convenient or maybe helpful to the government, right? So if the government wants to sponsor Lance Armstrong's cycling team and they think that'll help the post office business, whatever, right? Then they can do it. So one of the first crises in American history, at the very beginning, happened in George Washington's administration. Congress wanted to charter a Bank of the United States. And this bank would have issued credit, issued money, etc. I mean, don't think about it today, but at the time of the founding, every state had its own paper money. You had Maryland dollars, you had New York dollars, you had Virginia dollars. And this was not very good. So Congress said, let's put our own bank in every state. That way people can get U.S. currency. They can get U.S. money. I mean, it wasn't a crazy idea. But George Washington was conflicted. Could Congress create this bank? So and Marshall alludes to this. Can you imagine, right? You're George Washington. Who's in your cabinet that you can ask for advice? All right. So you got James Madison, you have Thomas Jefferson, and you have Alexander Hamilton. These are your advisors. Think of the jokers we have today, right? You have James Madison, Alexander Hamilton, and Thomas Jefferson are in your cabinet, and these are the people you ask for advice. So Washington goes to James Madison, and Madison goes, listen, the word there, which he wrote, by the way, right? He wrote it. The word Madison, listen, this means necessary, right? In other words, you can only exercise some sort of power if it's necessary, all right? So what provisions we have in the Constitution? Well, Congress has the power, if you go all the way to the top on page 23, the first three in particular. Congress has the power to lay and collect taxes. Congress has the power to borrow money. And Congress has the power to regulate commerce. Right, those are the first three listed. They can collect taxes, they can borrow money and regulate commerce. So is that Wade?
Yes.
Wade, sir. Is it absolutely necessary for Congress to collect taxes and borrow money to have a bank? Is it absolutely necessary?
I use the word absolutely, so it's sticking points, but no, not absolutely.
You're jumping to my point. Good. Is it necessary? Is it required for Congress to have a bank in order to regulate commerce, to borrow money, or lay taxes?
In the sense that it's appropriate, yes.
No, I said required.
Oh, required.
In the Madisonian sense.
No.
Okay. So Madison says, listen, you have these powers, right? Of course, they can lay taxes, they can borrow money, but do they really, really, really need a bank to do it? And Madison says, no, they don't need it. We can get by just fine without it. Now, maybe it might be more efficient to have a bank, maybe it would be more effective to have a bank, but that's not the question. It's, is it necessary? Jefferson agreed with Madison. So then, as often happens, when the president gets advice he doesn't like, he asks someone else. You know, it's like when mom says no, so he asks dad, and when dad says no, he asks grandma. It's basically this, both presidential administrations. So it's true. So Washington turns to, you know, Mr. Secretary of the Treasury, Alexander Hamilton, who hadn't been killed yet in a duel. And Hamilton says, oh, no, President Washington, that's not how you read the Constitution. I was there also. Me and James, you know, we were there, but that's not how you read it. Hamilton says, convenience, right? Is this something that can achieve some goal that will help it? If the answer is yes, then it's lawful. So I'll ask, is that Marianne? Is it convenient to the United States government to have a bank so they can collect taxes and borrow money? Of course. Why is it convenient? Makes it easier. Yeah, you have a bank in each state. You can give out paper money. You could, you know, lend credit, whatever. Okay. So here we have, in the first year of our republic, a debate between Hamilton, Madison, and George Washington. This was 1 year after the Constitution was ratified, and they couldn't agree on what the damn thing meant. So I give this to you as a lesson, saying that there are no right answers in this class. Please don't ask me for one, because there isn't. If Hamilton and Madison, who were there together in Philadelphia in 1787, can't agree on what the most important clause of the Constitution meant, we do our best. Okay? And so George Washington chartered the bank. He signed into law. That charter expired, and then Congress created a second Bank of the United States, which was chartered in 1816. Okay? A number of states resented these banks. They thought they were intrusions from the federal government into their local business. And a number of states, including Maryland, passed a law. And what these laws said was, unless your bank was incorporated under Maryland law, right, you got a Maryland charter to run your bank, we're going to tax you effectively $15,000 a year. This is a punitive tax that will put them out of business. That was a lot of money. So what happened? You had a bank in Baltimore, Maryland, and you had a guy named James McCulloch, and he's the clerk of the bank. And then a tax collector comes and says, hey, you're running a bank. It's not approved by the laws of Maryland. Here's a bill. And McCulloch says, screw off. And then things could have escalated very badly. So this could have been the cause of a civil war. I'm not exaggerating. This could have seriously fractured the country because the states did not want these federal banks in their property. So what happened? They went to court. They went to court. And this case was appealed to the Supreme Court of the United States. Okay? This case was argued over the course of 9 days by Daniel Webster. There were no briefs. Remarkably, John Marshall wrote this decision 3 days after the arguments finished. 3 days. You want to talk about your legal writing deadlines? He wrote this entire opinion in 3 days. Probably the most important 18th century, 19th century common law decision we have. So this case, right, had a couple key questions. So before you get to the question of can Maryland tax the bank, that's the second question. Can Maryland tax the bank? The first question is, does Congress have the power to create the bank? Does Congress have the power to create the bank? If you can imagine, during oral arguments, you had the lawyers quoting James Madison of what he said. Even better, you had the lawyers quoting John Marshall, who was a member of the Ratification Convention in Virginia. And John Marshall agreed with Madison, his fellow Virginian. So you had the lawyers saying, Marshall, you idiot, you said this 20 years ago, you couldn't do this. Look at James Madison, the father of the Constitution, saying you can't do this. What does Marshall do? He agrees with Hamilton. He goes with Hamilton. Why? Because this gives a much broader power to the federal government over these matters. He says basically, necessary means convenient. Okay? Congress can do things which are convenient to executing an enumerated power. So even though there's no power listed in the Constitution that allows the president to build a bank or Congress to build a bank, it's a necessary and proper incident, if you will. It's a means to an end to achieve the bank. Okay? And there's a couple important points I want you to take away from here. The sovereignty of the state of Maryland is important, right? They don't discount it. But what Marshall stresses is that the Constitution is the supreme law of the land. And any law of a state that's contrary to the supreme law of the land is unconstitutional. Maryland cannot tax a federal bank because, as we all know, the power to tax is the power to destroy. And if a state has the power to destroy the federal bank, that makes the entire Constitution worthless because the Constitution is supreme law of the land. Okay? So even though Congress doesn't have an explicit power, they can do this under their implied powers. And he makes a couple of textual points that are good. So I asked before, outside of Article 1, Section 8, does Congress have any powers? The answer is no. But the necessary and proper clause is in Article 1, Section 8. One after another, 18 things. Congress can do this, Congress can do this, Congress can do this. These are all grants of power. Now, what Marshall says is, listen, this is in there. That means this is a grant of power. It's not a limitation on power. This is a grant of power to Congress. All right? Marshall also makes important points which had a lot of foresight, saying this country is going to grow a lot in the next number of years. The Congress needs the power to react to situations which are not envisioned by the framers of the Constitution. That they should have this elastic power to kind of stretch based on the situation of the day. And here's the most famous explanation underlined in your book, where he says at the end, the holding, right? Let the end be legitimate. Call it the page we find. I don't have it. Let the end be legitimate. Let it be within the scope of the Constitution. And all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist of the letter and spirit of the Constitution, are constitutional. You want to find it? What page?
202.
202, thank you. I love it. I get this actually real nice breeze when you all flip your pages. It's like a fan. I'll read it again because this is a very important phrase. Let the end be legitimate. Let it be within the scope of the Constitution. And all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional. What does that mean, Madison? Fittingly, Madison, right? Sorry, you'll get that a lot this year. Sorry. What does that mean? What's Marshall saying there? Uh-huh.
The end of it, like the end goal of creating the bank is just and constitutional, and if the goal of whatever you're doing is within the scope of the Constitution and not expressly prohibited, then it's within the spirit of the Constitution and therefore constitutional.
Very good. Very good. What he's basically saying, as long as the government's acting lawfully, right? The bank is a good thing, as long as they're acting legitimately. And they're using means which are appropriate, using means which fit in with the constitutional scheme. And they're not prohibited. Congress do whatever they want. So as long as the ultimate goal, of raising taxes, borrowing money, as long as that's a valid goal, Congress can choose more or less whatever means necessary to get there. Congress can choose the means by which they act. Necessary only means convenient. Okay, so the court holds, one, Congress can create the bank, that this is a means to an end, that Congress has the power to do this. Second, they hold Maryland cannot tax a federal bank because the power to tax is the power to destroy, and this state law conflicts with the federal constitution. It cannot stand. Okay. So questions? Yes.
I don't understand what it means by a power to tax and power to destroy.
Oh, if Maryland could impose a $15,000 tax on the federal bank, could the federal bank continue to exist? What was a $100,000 tax? What was $1 million tax?
I mean, it depends.
Let me ask you this question. So you're in the state of Texas, right? If the state of Texas imposes a tax on the people of Texas, what's going to happen?
Well, people are going to feel
They're going to be angry, right?
Yeah.
And they might vote them out of office, right? But when the people of Maryland impose a tax on the federal government, what happens? Will the Maryland legislature have any negative consequence for that?
No, and I get why Maryland couldn't tax, like, it doesn't make sense for the state to tax, like, the US government, but I just don't get this one. Like, really destroy it.
Oh, it would. What if they made it? What if Maryland banned federal banks from operating in their state? They said, we will not, unless you comply with our laws, we will not allow your bank to even exist. You see the problem, right? States one by one can pick off federal entities they don't agree with. They basically exclude them from their state. That would be very bad. That's why we have a supremacy clause, which is that all state laws in conflict with the Constitution are void. You see? Other questions? I want to tease you with one thought. We've only been focusing on necessary here. What about proper? Can something be necessary but not proper? Obamacare. What the Supreme Court held, believe it or not, there have been 2 cases in our Supreme Court history deciding this issue. McCulloch and Obamacare. What the Supreme Court held in the Obamacare case was that the ACA was necessary but not proper. I'll come back to that later, but keep that in the back of your minds. All right, anything else? All right, have a great weekend, everyone. See you next time.